All right.
Okay,
Okay.
Jim, the floor is all yours. I'll just let people know that there'll be plenty of time for Q&A at the end, and we have Jennifer from the OIS who's also present to help answer questions along the way. Thank you so much, everyone, and we'll get started now.
All right. Good afternoon. I apologize. I somehow had the wrong link, and I'd been sitting in the room alone waiting for someone to come join me. But we've got it worked out now. There's a disclaimer. Johns Hopkins University does not endorse or recommend the law firm providing this presentation. Johns Hopkins University sponsorship policies on permanent residency and non-immigrant statuses such as H-1B or O-1 apply when the university is the petitioner. Consult OIS at international services at jhmi.edu with questions about employer sponsorship. So to begin with, my name is Jim Arkell. I'm an immigration attorney. I've been a lawyer for over 30 years. I'm with the Dunn law firm in Bloomington, Illinois, and it's been around for over 100 years. We represent several universities, and all I do is immigration for higher education. I'd say 80% of my work is on national interest waivers, and the other 20% is on EB-1A and EB-1B cases. I also work with my brother, Tom, who's been an immigration lawyer for over 20 years, and he works on pretty much everything. He does the H-1B, O-1, as well as other immigration areas, but my area is focused primarily on working with researchers, postdocs, PhD students, faculty members. So I was an F1 student at one point. I got a green card and eventually became a citizen. My brother did as well. Also working with us is Bong Mikiavis. Bong is a graduate from Notre Dame. He used to be the director of the international office at Notre Dame. And interestingly, he was once a consular officer working for the Department of State. He worked in different consulates and embassies around the world doing visa adjudications. So he brings a considerable amount of experience to the firm. So today, I'm going to go over some immigration updates, things that have changed since the last time I did a presentation approximately 6 months ago. Go through the different immigration status, non-immigrant statuses, and then how you can get permanent residence and a green card to live in the United States once you've completed either your PhD or your postdoc, or if you are a researcher now on perhaps a J1. So one of the things that has been of interest to a lot of people is NIW premium processing. This finally began on July 1st. But disappointingly, it was only for cases that were filed on or before June 1 of 2021. The USCIS has twice updated that date since July 1st. And the most recent was on September 15th, they updated it. So now if your case was filed on February 1st of this year or before, you're eligible for NIW premium processing. USCIS premium processing fee is $2,500, and the decision is within 45 days. So this is a little different than the EB-1A premium processing or EB-1B premium processing, which they guarantee it'll be within 45 days. We've done a few, I won't say several, we've done a few premium processings for NIW, and people often ask me, should I spend the $2,500? Is it worth it? I don't think it's worth it at this point because cases are becoming being adjudicated much quicker. If you have an older case that is languishing, that's been around a while, you might consider it. But I truly don't think unless you're in a hurry and there's a need to get a decision quickly, I don't think it's worth the $2,500. And the cases that we have filed for premium processing, the NIWs, they've all been approved, and most of them were approved within 5 to 10 days. So although they can take 45 days, they are processing them quite quickly. So whether to do it or not, up to you. Something that you should look at to determine whether there's an absolute need. Coincidentally, we have filed, there's 2 cases that we filed. We sent the premium processing application in, and the day after it was sent, the case was approved. And it hadn't been receipted by USCIS. In both cases, they returned the $2,500 premium processing fee. So if they approve it before they actually start doing the premium processing, there's a good chance that they will refund the premium processing fee. So that's interesting to note. Priority dates for the EB1 category are current for all countries. They have been for a while. Priority dates for EB2 category are current for all countries except India and China at present. In October, the priority date for China is now July 8th, 2019. This is moved forward from April. However, the biggest change is the EB2 priority date for India retrogressed October 1st. From December 2014 back to May 1, 2012. They announced this September 15th, and it's been a big disappointment. This came as quite a surprise. So we're hoping that those priority dates will move forward very quickly, because they had been advancing quite a bit over the last 6 to 8 months. And so to see this happen was a considerable disappointment, and we're hoping that that'll rectify itself soon. EAD extensions, if you have EAD and you need to do the renewal, effective in May of this year, the automatic renewal changed from 180 days to 540 days. This is a significant change. The reason for this is EAD renewals were taking more than 180 days. And so many people that had EADs and had filed their renewal, once the 180 days came, they were no longer eligible to work, and they had to wait for their renewal. And so many people were out of work for a month to 3 or 4 months, waiting to get their EAD renewed. And so this was an incredibly horrible situation for many, many people. It took USCIS, in my opinion, way too long to recognize and do something about this. But they did finally do something about it. And so the 180 days is to 540 days, at least for present. Good news is now, though, that USCIS is finally processing EADs much quicker. And what I've seen in the last couple of weeks with EAD approvals coming in is they're now getting done anywhere from 4 to 6 months. So they've gone from well over a year down to 4 to 6 months for the EADs approvals. EB1A and EB1B, there were some clarifications as to the adjudication guidelines for extraordinary ability, EB1A, and outstanding professor researcher, EB1B. Critical role can now be in a department as opposed to the entire organization. Used to be USCIS officers typically took the position that if you were working at, for example, Johns Hopkins University as a postdoc, they would say that you had to show that you had a leading or critical role within Johns Hopkins University. However, that is now changed, and they have clarified the guidelines such that if you have a leading or critical role within a department, as opposed to the entire organization, you can meet that criteria. And we have successfully used that criteria for postdoc researchers working in a lab that we could argue had a could be considered distinguished. So this has been a significant difference and very beneficial to postdoctoral researchers. Published material, USCIS often took the position that any published material in trade journals or major media had to be about the individual. They've now clarified that, and the published material can now be about the research that you have conducted, and it doesn't just have to be about you as an individual. So if there is published material about you in a trade journal or major media with a high circulation, and it's about your research, then that can be used to meet one of the several criteria. Additionally, published material now specifically includes mediums beyond print. So they had been, on most instances, including anything that was online or had a large circulation or large viewership, but some officers were not. And so for continuity, they have now formally recognized that that mediums do not have to just be print, and can now be a broad range of things. So optional practical training, F1 students. So if any of you are an F1, you're authorized for up to 12 months of full-time OPT at each educational level. I just talked to a client today who had some issues, and they've got multiple master's degrees and just finished an additional master's recently. And they were wondering if they could get additional OPT, but they'd already used their OPT at that level. So if you can use OPT at the bachelor's level, you can use OPT again at the master's level, and you can use OPT again at the doctorate level. However, if you get multiple degrees at one level, you cannot get multiple years of OPT. And so it's at each educational level, not for each degree obtained. If you are in a STEM area, you can get 24-month extension, so a total of 36 months of optional practical training. This is if you have finished your degree in a STEM field. Now, don't assume that your degree falls within the STEM field. I've had people contact me in a panic in the past because they learned at the last minute that they did not qualify for the STEM extension. And so make sure you qualify for the STEM extension. Don't make that assumption. One of the things that has happened in the past year is there were new STEM initiatives put out by the White House. And as a result, there are now 22 new areas of study that are now eligible for the STEM extension. So make sure that you look at your area of study carefully. See if your area now qualifies for a STEM extension. And so that is something to look at carefully. The other thing not to make an assumption about is whether or not the employer that you're working for under OPT is enrolled in E-Verify. Again, I've had several people call me in the past in a panic because they found out their employer was not enrolled in E-Verify, and therefore they could not get their STEM extension with that employer. So don't make those assumptions. Don't assume you qualify for STEM. Make sure you do, and also e-verify. You should apply on time, 90 days before the current post-completion OPT expires. So if you can get an extension, make sure you apply soon. Again, extensions may take a little longer than expected. Don't file before your eligibility because USCIS will reject it if it's filed outside of the 90-day window. You're allowed 90 days of unemployment during the first year of OPT, and if you qualify for STEM, you can have up to 150 days during that 3-year period. So if you're not on an F1, there's a good chance that you're on a J1 visa. The J1 visa is operated by the Department of State, and it is intended as a cultural exchange program between the United States and other countries of the world. So the purpose of the J1 is for people to come here, learn about the US, learn about different areas of study, and take that knowledge and experience back to their home country. And so because of that, there is often a 2-year home residence requirement. This is 212E is what it will say on your J1 visa in your passport. And it'll say whether you are subject to 212E or not subject to 212E. You can have up to 5 years on your J1. That's the maximum you can be on a J1. You can adjust status from a J1 visa directly to a green card if you're not subject to the 2-year home residency requirement or you've obtained a waiver. So many people are under the mistaken belief that a J1, you have to go from J1 to an H1B in order to get a green card. That's not the case. You can go straight from a J1 to a green card if you're eligible. For example, if you're qualified for a national interest waiver, you can go and file for the national interest waiver, even if you're subject to the 2-year rule. So the 2-year rule does not affect your ability to file an NIW petition, an EB1A petition, EB1B petition. You can still file those petitions subject to the 2-year home residency requirement. What the 2-year home residency requirement limits you from doing is being able to adjust status to a green card or being able to obtain an H1B. So if you're subject to the 2-year home residency requirement, you can get a waiver. So if you're not sure whether the J1 2-year home residency requirement applies, you can contact the Department of State. Their website has information about the J1, has information on how to apply for an advisory opinion. So you can file an advisory opinion with the Department of State and simply ask them whether or not the 2-year rule applies to you. And then if the advisory opinion comes back favorably, you can move forward with your adjustment of status or obtaining an H1B if that may be the case. If it comes back that you're subject to the 2-year rule, you can then file a waiver. The waiver is also done through the Department of State website. So the 2-year home residency requirement typically is a result of the skills list. So depending from what country you are from, they have a skills list that may apply to your home country. If your field of expertise, your area of study, or the reason you're here in the US falls on that list, you're automatically subject to the 2-year home residency requirement. The other areas that cause you to be subject to 2 years if you have government funding, direct government funding, either directly from your government or from the US. or you're here for medical training, typically as a physician. If you are here subject to government funding or medical training, it can be more difficult to get a J1 waiver. It can be done, but it's a little more difficult. Recently, I've done several J1 waivers based on government funding from Brazil. So you had to get a no objection letter from the funding source in Brazil. You then have to file the J1 waiver, get a no objection letter from the Brazilian embassy in Washington, D.C., based on the no objection letter from home. And then the Department of State then confirms that there is no objection from the funding source. And the J1 waiver for those cases both took approximately 6 months. So those are two recent ones that have just come in. So they're at the top of my head based on the approvals that have just come in. And so the waivers for no objection are pretty straightforward. Otherwise, if you can't get it through no objection, you'll have to do it based on hardship, and those can be a considerable challenge. Best time to file the J1 waiver is when you've exhausted your J1 extensions. So once you've got your last extension, you can file for the waiver. If you know you're going to an H-1B or you've had your I-140 approved, you can look at it, but the timing of filing that waiver is very important, because once you file the waiver, you cannot extend it. So be very careful with when you file the waiver. If you're subject to the 2-year home residency requirement, you must fulfill the 2 years in the home country or the country designated as your residence on your DS 2019. So for example, if you're from Colombia and you're subject to the 2-year home residency requirement, you cannot go to Canada, work in Canada for 2 years, and then come back to the United States. You must do it in your home residency, in your home country as designated. So it's not leave the US for 2 years, it's to go home for 2 years. H-1B, if you're not on a F1 or a J1, perhaps you're on an H-1B. So the H-1B is different from the F1 and the J1 from the standpoint that it has dual intent. It makes transitioning to a new visa status less restrictive. Maximum stay of 6 years on an H-1B, unless you have an approved I-140, which will allow you to stay beyond the 6 years. The only time that tends to come into play is for Indian nationals because of the long priority date. And so if you are an Indian national and you have an approved I-140 and the priority date is a ways away, you can stay on an H-1B past 6 years until your priority date comes current. You have to be in a professional or specialty occupation, which requires a bachelor's degree or equivalent. So the job position has to have an education requirement of bachelor's or better. It is employer specific, meaning that you can only work for the employer who has sponsored your H-1B. It is location specific, meaning you can only work in the location designated for the H-1B. So even if you're working for the same employer and you get transferred to a different location, then you have to amend the H-1B. For example, where I live is the world headquarters for State Farm Insurance, and they opened large offices in Dallas and Phoenix. And so if they were working here in Bloomington, Illinois, and then were transferred to the Dallas office, even though they were doing the same job for the same company, they would have to get their H-1B amended because they were moving to a new location. Additionally, if you're working for the same employer, same location, but you get a promotion, you're no longer in the same job, and the H-1B is job specific, you would have to amend the H-1B. So prevailing wage, this is the reason that they are job and location specific. The employer has to pay the prevailing wage, which is the salary that is determined by the Department of Labor, which is appropriate for that job in that location. So salaries in, for example, you were in Dallas, you got transferred to Phoenix. The salaries in Phoenix might be lower than it is in Dallas because of cost of living. Therefore, the prevailing wage, they would not have to pay you as much in Phoenix as they did in Dallas, perhaps, because the prevailing wage would be different. But the employer must pay 100% of the prevailing wage or the actual wage, which is ever higher. And the prevailing wage is based on minimum requirements of the job and the area of intended employment. And the actual wage is the amount being paid to others with the same or similar qualifications and experience. So if the person next to you is doing the exact same thing you are, they're a US national or a permanent resident, they're not subject to a prevailing wage. If they're making more than you are and your qualifications are basically the same, then your employer is breaking the law. They're required to pay you the prevailing wage or the actual wage, whichever is higher. So the H-1B visa annual cap, if you are petitioned by an institution of higher education or institution or a entity that's affiliated directly with an institution of higher education, there is no annual cap. It means there's an unlimited number of H-1Bs for institutions of higher education. If you're going into industry, then you have to go through a lottery. The number of H-1Bs are capped annually at 65,000 for people without a advanced degree from a US institution. If you have an advanced degree from a US institution, then there's an additional 20,000 that are available. So if you apply, your chances are out of 85,000 as opposed to 65,000. It truly is a lottery. They anticipate anywhere from 400 to 500,000 applications for those 85,000 visas for industry this year. The lottery has already taken place for the 2023. So the next lottery will take place in April of 2023, and visas become available October 1st of each year. Extensions, amendments, and change of employer petitions are not subject to the cap. So other non-immigrant visas, you have the TN, the L1, the O1, the H-1B1, and the E3. So the O1, we'll talk about that in a little more detail. The others typically won't apply unless you're from Canada, Mexico, Chile, Singapore, or Australia. But the O1 is an extraordinary ability non-immigrant visa that is similar to an EB-1A. To get an O1, you must meet 3 of the 10 criteria. It's the same criteria as used for the EB-1A. We'll look at those in a minute. However, there's no final merits determination, meaning if you can meet 3 of the 10 criteria, your O1 will be approved. The first O1 is typically valid for 3 years. It must be renewed annually after the first 3 years. However, there's no limit to the number of renewals. And it's an excellent choice for postdocs who are subject to the 2-year home residency requirement. So if you're on a J1 and you're subject to the 2-year home residency requirement, and you don't want to go home and you have an employer that's willing to sponsor you for an O1, you can stay here indefinitely on an O1. And so you can also, during that time, every time you go back to your home country for a couple of months for vacation, you can accrue up to 24 months of home residency during an extended period of time and meet your 2 years that way and still manage to live in the US, work in the US on an O1. And so we do quite a few O1s for people who are subject to the 2-year home residency requirement. So permanent residence, that is the goal of many people who come to the US, is to obtain a green card. I don't know that that was my goal when I came here to go to school many years ago, but after I'd been here a while, it certainly did become something that I wanted, because I knew I wanted to stay and live here. So the easiest way and the most common way to get a green card is family-based, basically through marriage. So if you marry a US citizen or marry someone with a green card, they can sponsor you for permanent residence. And that is the most straightforward way to obtain permanent residence. The other way to get permanent residence that we'll talk about is an employment-based green card. So an employment-based green card, if it's sponsored by an employer, there's a labor certification. They call it the PERM process, where the employer must test the US job market. So they have to advertise the position to make sure there is not a US worker available for that position. Once the PERM process is satisfied, then the employer can file an I-140 on behalf of the employee, and you can get an EB-2 sponsored by the employer, which when your priority date becomes current, you can apply to adjust status to a green card. Another employment base that requires employer sponsor is the EB-1B, Outstanding Professor Researcher. We file several of these every year, but the EB-1B requires you to have sponsorship from your employer. So just as if you are a professor, researcher looking for an EB-1B, you would have to address those issues with Johns Hopkins directly, just the same as with an H-1B or an O-1, because they are employer sponsored. The I-140, again, filed by the employer, if approved, adjust status to green card. So ways to self-petition where you do not need your employer to sponsor you. The most common is the EB-2 National Interest Waiver. Again, that is the vast majority of the cases I handle. The other is the Extraordinary Ability EB-1A. You do not need a sponsor. And the third is the EB-5 Investment Visa. For obvious reasons, we'll talk about the EB-2 and the EB-1A The EB-5, if you happen to have $1 million or so laying around, you can invest it through an EB-5 and obtain a green card at some point. So the NIW EB-2, like the EB-1A, does not require employer sponsorship, so you skip the labor certification process. Your job does not have to be advertised. Even if there are other Americans that are available that could do your job, because your job is in the national interest, it is worth waiving the requirement to see, because your work is of national interest and of benefit to the country. There's no need to go through the PERM process. There are new USCIS adjudication guidelines for persons who have an advanced STEM degree. And if you are working in the area of your STEM expertise, or you are advancing critical or emerging technologies, these critical and emerging technologies are listed by the US government. And if your work falls in those areas, then there's a higher chance of success under these new adjudication guidelines. We've been using them with very good success. Processing times have significantly improved. We are getting cases approved out of Texas in anywhere to 3 to 6 months for more recently filed cases. We do have some cases that were filed during the pandemic that are still lingering a little bit. Like I said, we filed a handful of premium processing requests on some of the older cases, and even had some approved while those premium processing requests were in the mail. So cases have improved significantly. And this is one of the reasons I don't recommend filing premium processing, because there's a very good chance your case will get approved fairly quickly. Even if you've had one pending for a year or more, I suspect it'll get a decision within the next few months. More recently, cases that we filed, for example, I would say starting February, March of 2022, many of those have already come back or are coming back now. So what had been delayed to over a year, up to 2 years in some cases, is now moving much quicker. So that is probably the best news of anything that we've had over the past year, is the improvement in processing times. Our website, nationalinterestwaivers.com. The things that I've talked about here, for example, the new guidelines, I talked about the critical and emerging technologies list. I have a blog on that website, and you can read about updates and things that are going on. And on the blog, I link to the source material. So if you go to that blog and you want to see what's on the critical and emerging technologies list, you can go to our website, look at it, and those links will take you directly there. So NIW criteria. So there are 3 criteria for the NIW. The first is that the proposed endeavor has both substantial merit and national importance. This is forward-looking. So prong 1 is, what are you going to be doing in the future? So you have to focus on your current research and what research you will be doing if you're a researcher. If you're not a researcher and you work in a different area, how is the work that you're doing and going to be doing of national importance? So it's forward-looking. The second prong, that you're well positioned to advance your proposed endeavor, is based upon your past success. This is where your education, experience, and past successes come into play. This is where they look at, for example, publication and citation record, patents that are being commercially utilized, how your work is being done if you're not necessarily doing scientific research, but doing more public policy research, how is the work that you've done being implemented into reports that people are using? So there's a lot of different ways to show past success. And the third one is, this is the national interest. On balance, it would be beneficial to the United States to waive the job offer and labor certification requirements that are necessary under a typical EB-2 employer-sponsored. So if what you're doing is in the national interest, you're qualified to do it, and your work has national importance, therefore it's in the national interest for you to remain in the US, then it's worthwhile to waive the labor certification. If you get the first two, the third one typically follows. Am I qualified for an NIW? That's the question we often get. The best way to find out is to contact Kayla and schedule a free, no obligation consultation. As a thank you for the opportunity to spend time with you and for your time, we are happy to answer any questions you have. There's already several questions in the chat. But if you would like to know if you qualify for an NIW, I am happy to talk to you about it. Even if you're not qualified, I can explain to you what you may need to do to strengthen your case down the road. There's no obligation to hire us. There's no charge for it. And if you have questions, perhaps about a J1 or other things of that nature, about waivers, I'm happy to talk to you about that. Again, this is our thanks to you for your time and the opportunity to speak with you today. Again, if you have questions about H-1Bs, O-1, EB-1Bs, you should talk to the people at Johns Hopkins, as they're the ones that sponsor those things, and they're better suited to answer those questions: F1s, O1s, H1Bs, EB1Bs, anything that they're directly involved with. Can I apply directly from J1 or F1 OPT status for national interest waiver? You absolutely can. Is it necessary to be first author? Not at all. You can be a second, third, fourth author. You don't even have to have any publications. I've gotten many green cards through the NIW process for people that have no publications and no citations. So there is no citation limit or requirement. I've gotten several cases approved over the past couple of years with single-digit citation numbers. So it's about the work you do and the work you're going to do, and whether we can show that you are well qualified to do it, and there's a good chance that you will have success in the future. Extraordinary ability, EB1. I only recommend an EB1A in the instance of people that may be from India or China. There's really no reason, because of priority dates being current, for EB2 NIWs for anybody from any country other than India or China to even consider an EB1A. It does happen in some circumstances where an EB1A may be a better choice, but it's not going to be very often unless you're in a real hurry and there's a deadline. It's much easier to get an NIW, so the EB1A is typically not the best solution unless you're from India or China and you have to deal with priority dates. You must meet 3 of the 10 criteria. Employer sponsors not required. Premium processing immediately is available. However, the final merits determination is the biggest challenge, and this is where postdocs typically run into difficulty. Because you're a postdoc, you're still considered to be training. And a lot of USCIS officers will say, as a postdoc, due to the fact that you're still training, you have not risen to be one of the small percentage of people in your field who have risen to the very top. And that's what the EB1A is: extraordinary ability. You've risen to the top of your endeavor, your field. And they will compare you to the people who write letters for you, and they'll say, this person has 10,000 sites, you have 1,000. It's a very simplified way of doing it for some officers. It's an incorrect analysis, but I've seen it done on several occasions. So they'll compare you to the people writing letters for you to argue that you've not risen to the top of your field if they're going to deny your case. We have had EB-1As approved for postdocs with less than 100 sites. It's very officer specific. So with the EB-1A, there is an element of luck involved because there are officers that simply won't approve EB-1As and for postdocs. So it's not something that I would recommend for the vast majority, but it may be something that'll work for some of you. These are the criteria. They're the same criteria for an O1. You can find these online. They're easy to find. The three that are typically used are research published in a peer-reviewed journal, that you've done peer review, and that you have had original contributions of major significance to your field. Final step, permanent residence. Once you have an I-140 approved or an I-130 if it's family-based, you file an I-45 adjustment of status. This is when you include your family members. It can file concurrently with the I-140. Priority date is current. There are timing issues regarding whether you should file concurrently or not. I would not file an I-140 and an I-45 concurrently without first discussing it with a lawyer, because it can have a significant impact on you to file an I-140 and an I-45 concurrently. So I wouldn't do that without first talking to a lawyer, even if it's just for 30 minutes to discuss whether or not filing concurrently is a good idea. And this is where they do a background check medical exam. They now are waiving the majority of interviews for the green card, and they're issuing them in the mail. Once you've had your green card on an employment base for 5 years, you can get US citizenship. So I will start doing questions. We'll stop the recording so that we can have some